Divorce Talk Radio does not give legal advice, neither does it reflect the views of Rockford College. To obtain legal advice, you need to retain an attorney in your own jurisdiction. Good evening, folks, and welcome to Divorce Talk Radio. I am here in the studio with attorney Tamika Walker. This is attorney Brad Tengler. Hey, Tamika, how are you?
I'm good, thank you. How are you?
Today, I'm doing great. Today, our topic of conversation is maintenance in divorce cases. But before we begin with that topic, can you give a little background about yourself, Tamika?
Sure. I am originally from Indianapolis, Indiana. I attended law school at Case Western Reserve University in Cleveland, Ohio. And I have been in the Rockford area practicing law since 2006. I've been with my current firm of Shreenan and Kane since, I believe, 2010. And I practice primarily family law here in the community. I also practice in Boone County, Stevenson County, and Ogle County primarily, as well as Winnebago.
And today we're talking about maintenance. Can you give our audience a little bit of background and definition of the basics of maintenance?
Yes, maintenance is what used to be called alimony. And maintenance typically happens probably more in high-income cases or cases where there is an extreme income disparity between the parties. So what that basically means, just as a really easy example, I have a housewife who, while she contributes, women definitely contribute to the household and to the income of the family, but her work is primarily at home, so she's not bringing in dollars, okay? So she's bringing in zero. And her husband, he makes $100,000 a year doing very well. They are now getting ready to separate. Well, if her husband gets to walk away and take his $100,000 a year and she's just now entering the workforce, it'll be very hard for her to maintain the standard of living with which she had while she was married. So that may be a maintenance case. One of the big issues in maintenance that a lot of people don't really know about is the tax consequences. Maintenance is a tax deduction for the person that pays it. So, for example, that $100,000 gentleman, if he has to pay her $1,000 a month in maintenance, that's $12,000 a year that comes off of his gross income. So,
because that's not considered part of his income.
Correct.
Right? It's her income.
But now it will be considered for her income, and she would have to pay taxes on the $12,000 that she will receive.
So basically what maintenance is an amount of money provided to the other spouse who makes less for a number of reasons.
Correct.
Okay. And are there different types of maintenance that courts order? Yes.
There can be temporary maintenance, there can be permanent maintenance, there can be rehabilitative maintenance. It all depends on the case. I don't think any lawyer can predict what a judge will order. Maintenance can be temporary during the course of the divorce proceedings and then stop. It can be rehabilitative, which means it occurs after the judgment for dissolution, but only for a specific period of time so that the wife or the husband, because it goes both ways, can get on his or her feet, or it can be permanent. Now, even when you hear the word permanent, it doesn't necessarily mean forever. There are reasons why maintenance can end, and some of those reasons would be the death of the person that pays maintenance, the death of the person that receives maintenance. If the person that receives maintenance starts to live with another person on what's called a continuing conjugal basis. If you ask me what that means, I would tell you it depends on where you live. Different courts have made different rulings regarding what a continuing conjugal basis is. But those are some of the reasons why maintenance can end. So even as the world of divorce, we know nothing is ever truly permanent. Even permanent maintenance can end.
Not necessarily permanent.
Absolutely.
Let's talk a little bit about temporary maintenance.
Okay.
You mentioned that briefly. Mm-hmm. What is temporary maintenance? When is it ordered? How temporary is temporary maintenance?
It is very case specific, but temporary maintenance would actually occur during the course of the divorce proceedings. So either party can come in and ask the court to award some maintenance, and it's temporary, and it can change. It depends on the factors, such as if a person is ordered to pay temporary maintenance, but then they lose their job. They can bring a petition before the court and ask to stop that maintenance because the circumstances have changed. The temporary maintenance can last throughout the course of the dissolution proceedings, and then it could stop or then be converted to another form of maintenance or time-specific maintenance post the judgment for dissolution.
So temporary maintenance is about giving financial relief to the spouse that doesn't make as much during the pendency of the divorce action.
Absolutely.
So prior to the actual divorce
Yes.
being finalized.
Yes.
What is rehabilitative maintenance?
Well, rehabilitative maintenance is there to, just the way it sounds, to rehabilitate, to help the person get on their feet. So let's say we have that housewife who's been a housewife for 20 years, but she is in a great situation where she has a college degree. She's a teacher. So
Sure.
she may need some time to go back to school to get her certifications and things in order. Rehabilitative maintenance would be typically the type of maintenance that's ordered in that case to give her enough time to go back to school, to do what she needs to do to get on her feet, so therefore then she can earn money on her own and not be in need of support.
So you've got like a mom who's 35 with 3 kids,
Right.
ages 3, 7, and 9.
Correct.
During the past 12 years, she's spent her life pretty much making sure these kids get up and get to school and all those kinds of things, and had to pretty much not get educated because
Right.
she had to take care of the kids.
Right.
But now, since they're getting divorced and she doesn't have access to the husband's income, she needs a career.
Correct.
And so the judge is going to order rehabilitative maintenance?
Definitely a judge could
How long
order
does that last? 5 years, 2 years, 10 years?
It would depend on the case. Like the situation, the example we're giving, it may take a year or two for her to, recertify and do what she needs to do. It can be 2 years. It could be 5 years. Every maintenance award is case specific. There are no hard and fast rules.
Unlike child support, which seems more, hard and fast?
Well, because the judge has to look at several different factors.
Okay.
I can give you an example. Recently, I went to a continuing legal education seminar, and we did basically what's called a maintenance boot camp. We had 2 attorneys do arguments as it relates to maintenance. We had 3 judges listen to those arguments. These are 3 real judges practicing in Illinois that sit before family courts in Illinois.
Sure.
All 3 judges had a different explanation for what maintenance should be. Every judge awarded maintenance, but they each awarded different amounts. And I think it ranged from $2,500 to about $7,500 a month. So that's
Wow.
how wide the range can be. It is very much dependent upon your judge. It is very much dependent upon your circumstances. For example, the fact pattern in that particular seminar was the husband and wife had businesses. I mean, these were people who had they were very wealthy. And the husband was paying the wife a property settlement on a monthly basis. And then there was also a request for maintenance. Even though she was receiving that property settlement each month, the court still determined that maintenance was appropriate. So, and it actually was in that
Right.
case. It's very interesting. The factors that the court has to consider are specific to each case. The judge has to look at the income of the parties, the needs of the parties, the present and future earning capacity of the parties, if there are impairments to seeking employment, the time necessary to enable a party to seek maintenance, to acquire appropriate education and training. That's something where we look at, especially in that rehabilitative piece. We look at the standard of living established during the marriage, how long the parties have been married, the age, physical, and emotional condition of the parties. A lot of times you have people come in and see you and they're 33 and they want maintenance forever. Well, if you're 33, you probably can, you're not in a situation where you can't get educated or go out and seek, some additional education or employment or training. So it's hard for younger people to get permanent maintenance, obviously, because they have the ability to get second and third careers. You also have to look at the tax consequences of the division of the property, the contribution and services by the party seeking maintenance to the education, training, and career of the other person, if there are any valid agreements between the parties. And then here's the big one. Any other factor that the court expressly finds to be just and equitable. So that means you can consider just about anything.
Sure.
And that's why there are no hard and fast answers as to what a judge will do.
So all of the items that you just listed are from the statute,
Absolutely.
correct? And where is that statute?
That statute is 750 ILCS 5/504. That's part of the Illinois Dissolution of Marriage Act.
But what's interesting is your previous story about how these fake arguments occurred in front of 3 different judges, and you had maintenance awards ranging from $2,500 a month to $7,500 a month. even though they were all using the same factors
Correct.
to evaluate the case. That can be kind of scary to litigants.
It's very subjective, and that's why it's very hard for people to come in and see attorneys like yourself and myself. Well, what is the judge going to do? I don't know. It depends on the judge, and you do have to know your audience. You do have an opportunity to know these judges that we're in front of on a very regular basis, but you don't know what the judge is going to do. You can't ever guess. You know, there's a big difference between someone that's 30 and someone that's 60.
Sure.
You know, someone that has no education versus someone that has one or two or more college degrees. Their ability to be employable. The standard of living is a very hard topic for people. It's, I think, an unrealistic expectation for people to be able to live at the same standard of which they live together. Because you're essentially taking two people living on one income in one home. Now we're going to have two people living on possibly that same one income in two homes. So whereas you had one mortgage or rental amount, one, set of utility bills,
sure,
one set of expenses, groceries, all of those things, now we're splitting that up into two. And it gets much more expensive. Exactly. Two sets of utility payments, two sets of grocery bills, and that sort of thing. And obviously there are some adjustments when you go from two people to one, but still to have whatever the amount of money it is you're using for one household to now be stretched for two, it's impossible to live at the same standard of living unless you are making astronomical amounts of money.
So how do judges interpret that factor?
I'm not sure. I don't have a lot of judges that specifically talk about that. I haven't had that very regularly. So I think it just depends on your judge and what their opinion is.
When it comes to judges making determinations of how to split up debts in terms of maintenance or in providing maintenance, are there any kind of financial disclosures that are required?
Yes.
What are those?
Typically, at least I do, I ask every potential client, new client, to fill out what's called a financial affidavit. And that's where we talk about the income of the party, the expenses of the party. And one of the things that's very important probably for your listeners and anyone that's going into divorce court is be honest. Because it is an affidavit. And not only that, if we have to have a hearing on maintenance or a hearing on child support or what have you, if you go into court and you're telling the judge, oh, I pay $1,000 a month rent, I pay $600 a month in groceries, this, that, and the other, and then you have to testify, and someone asks you about the $1,000 a month rent, and then you find out you have a roommate and you're only paying $500 a month rent, you've now lost some credibility with that judge. Whatever your expenses are, that's what they are. It's very important to be honest.
You use the word affidavit.
Mm-hmm.
What is an affidavit?
It's a sworn document. You're basically telling the judge this is the absolute truth.
Under penalty of perjury.
Absolutely.
Meaning that if you intentionally lie, it's a crime.
It is. It is.
And that's what raises the severity of the situation and being honest, in addition to losing credibility.
And I think while the criminal penalties are there, I think for our purposes, it's more important for our clients to appear to be honest with the court, because the judge is the person that's going to hear this case, and they are very busy. But when you start having hearings and you start to have hearings on every issue, they're going to remember who's truthful, and they take that into consideration and they take it very seriously. You asked me a few moments ago, are there any other documents that we use? In addition to the financial affidavit, another document could be a statement of assets and liabilities, where you have to list what your assets are, what your debts are, for the court's awareness.
So, for instance, if someone has access to a 401k with $400,000 in it, that might be important to a discussion about maintenance?
It is, but it isn't. And here's why. If you're not at retirement age, you can't access those funds without a penalty. The purpose of the court is not to liquidate the person's assets, okay? Because that 401k may be divided in the property segment of the divorce. We have to look at things such as where we look at the maintenance issues, then there are also property issues. And part of the property is your assets and also your debts. who's paying what bills, who's getting what properties and bank accounts and that sort of thing.
So 401ks, retirement accounts,
those will be
real
property.
estate, those are
Property.
permanent property
Yes.
issues, whereas maintenance is monthly payments
Correct.
based on someone's income
Correct.
or stock dividends.
Well, if you're receiving those funds, yeah. I mean, but if you're not receiving those funds, let's say you like, for example, if you have stock in Eli Lilly and you get a dividend, but instead of collecting the dividend each month, you let it roll over and purchase more stock, well, your stock is now a piece of property that would then could be divided in the property allocation of the divorce. So what I'm saying is, it's not that the stock isn't important, but you're not receiving any money each month. What we're looking at in maintenance really is, how much money do you have each month? What are you bringing into the marriage? So if you're receiving stock proceeds, great. If you're not, that's a separate issue.
Sure.
But it's really about what is your paycheck and what are any additional income streams that you have.
We talked about temporary maintenance, rehabilitative maintenance. There's also something called reviewable maintenance, correct?
Yes.
What is that?
Well, reviewable maintenance means you have maintenance for a period of time, and then you come back to court, and the court reviews it to determine if maintenance needs to continue, or if maintenance can end, if the maintenance can be reduced, if the maintenance needs to be increased. It's essentially a review as to where we are at that particular point in time.
When do you perceive reviewable maintenance as a benefit to your client, and when do you perceive it as not a benefit to your client?
I think it depends on who my client is. If my client is the person that's paying maintenance, I definitely want maintenance reviews, because anytime I can get maintenance reduced for that client or eliminated for that client, that's great.
As opposed to permanent maintenance.
Correct.
Where he's stuck or she's stuck with it for paying it for the next how many years that
Absolutely.
other person is alive.
Now, keep in mind we're talking about divorce. With divorce, nothing is ever permanent and nothing is ever over. So even if you have a permanent maintenance award, if you have a substantial change in circumstances, you can still come back into court and request it be modified.
That's interesting.
Mm-hmm.
So that's interesting, because then the difference between reviewable and permanent becomes more gray.
A little bit. Reviewable means you know when you're coming in to review it. If it's a period of maintenance for 3 years, permanent maintenance, or you just do a period of maintenance for 3 years and it's reviewed at that time. I think the payor, the person that's paying, at that point at least has their eye at the end of the line. They can see a light at the end of the tunnel that maybe at this 3-year period it may be over, versus an award of permanent maintenance. Now, obviously, if I'm representing the person on the other side, I don't want maintenance reviewed. I want the person paying to have to do something affirmatively to get maintenance modified. So I would love to have permanent maintenance for every client that's receiving it. Is that a realistic expectation? No.
Sure.
But the more assurances that I can give to my client who's the receiver of the maintenance, the better off I am. The better off my client is.
So let me give an example.
Okay.
Say I marry when I'm 20 years old, and my wife, we work together, we have 3 kids, but she goes to med school. We're now 40. Mm-hmm. We've got our 3 children. I barely have any career skills whatsoever. The judge orders maintenance, 5 years reviewable. Mm-hmm. I'm now almost 45. We divorced when we were 40. I'm almost 45, and the review time is almost up. What do I have to do?
Well, you will come.
Or do I have to do anything?
Well, what our judges here in Winnebago County, what I've seen is they will set a review date. So they will tell you when you're coming back to court. So you will have that date already set, or you need to contact your attorney and ask, when is our review date, or can we get in for a review date? We go into court, and if the judge will review it at that time, I think you probably have to present your financial affidavit, explain to the court what's going on in your life. You may have to have a hearing. Honestly, it depends on the judge and how they want to hold those proceedings.
So some judges might make you present additional affirmative evidence that you're still in need of maintenance. I'm thinking about burdens. Who has the burden of proof in a situation like that? But it might depend on the judge.
Yeah, I think the judge really sets the tone as to how they will handle a reviewable maintenance situation. Fortunately for me, I haven't had very many, so I haven't had that situation really come up just yet. But I'm sure I'm getting there very soon. So
with permanent, though, like you were saying, the person who is ordered to pay permanent maintenance, if he or she has a change in circumstances, she's got to go in the court
correct.
And say, Judge, I don't make $100,000 anymore. I make $50,000 now.
And the burden is on them to prove that, and they have to show the substantial change in their circumstances. A lot of times that occurs when a person has been working for a very long period of time, but then goes on Social Security or stops working due to retirement and that sort of thing. That usually, it can be very difficult for people, but that's typically a kind of a benchmark when you're dealing with those permanent maintenance modifications.
You used the phrase previously a little while ago called continuing conjugal relationship. Mm-hmm. What is that?
It depends. It depends. Just based on the way it sounds, basically, if you are living with someone as if they are your spouse or truly a significant other, you're having sex with that person, you all are sharing expenses, that sort of thing. Now,
and that functions as a bar to maintenance, or it stops maintenance.
Correct.
Okay.
But some courts have deemed that to be very, very liberal. For example, I believe it's the Fourth Circuit, but I'll have to look into that and get back with you.
Sure.
That ruled that a continuing conjugal basis was just two people who lived in separate houses. Only one person had a key to the other person's house, but they did things together. It was very loose. And they ruled that was a continuing conjugal basis and stopped maintenance.
Really?
Yeah.
So their interpretation of whether or not their relationship was like a marriage was very, very broad.
Yeah. So I would say you need to, when you have if you have an attorney and that's an issue for you, your attorney really needs to do the research for the circuit that you're in. So what that means is when you, we have trial courts here, and then we also have appellate courts. There are different appellate courts in the state of Illinois, and those courts rule over certain counties. And then obviously you have the Supreme Court, which is over everybody.
Right.
So whichever circuit you're in, you need to find out what those judges have said as a continuing conjugal basis to give you a guide.
Because our trial judges are bound
Correct.
by the appellate court that
Correct.
rules over them.
Mm-hmm.
That makes sense. Are there any proposed changes in the maintenance statute that are on the horizon?
There are. There's House Bill 2337. It has been re-referred to the Rules Committee as of right now, so I don't know if it's dead yet or not, but there is a proposed maintenance rewrite for the statute. It actually gives a formula and gives specific guidelines for maintenance in situations when the combined gross income of the parties is less than $250,000, and if there is not a multiple family situation. And then it gives specifics as to how maintenance is calculated and even gives a formula. It also gives a duration guideline, such as if the marriage is between 0 to 5 years, 5 to 10 years, 10 to 15 years, 15 to 20 years, or 20 or more years.
That is quite a change.
It is a very big change.
So we have guidelines for if the combined income of the spouses is less than $250,000. Mm-hmm. These are the guidelines, and then duration periods. What does it say in regards to?
Well, the duration period. What I mean by that is there's a specific formula you use, and then you need a chart and a graph to figure this thing out. But basically, you take 30% of the payor's gross income, 20% of the payee's gross income, and there's a multiplier that you use based on the years that you've been married.
Is this going to be more mathematical, like the child support statute?
It is. It's much more mathematical.
Which could help maybe some of the ambiguity in wondering what is the judge going to rule if we have something that's more mathematical like the child support statute.
Yes. And it talks about a fixed term of maintenance. It's an interesting statute. I would definitely encourage practitioners to review it, see what you think about it.
Is there a lot of, are you aware of whether or not there's a lot of support in the Illinois Congress for this?
Well, I think there's the Family Law Section Council through the Bar Association, I believe, is in support of this. I'm not sure in terms of the legislators in our, General Assembly what their positions are at this point. I mean, it's been re-referred to the Rules Committee, so I don't know if that means it's going to stay there and die there this legislative session, or if it will eventually come out of the Rules Committee and come up for a vote.
Do you see strengths or specific weaknesses about the new proposed legislation?
One of my major concerns is how do you take this into account when there's child support? Because it could result in one party paying so much more to the other spouse. And that's what my concern is. And I haven't had an opportunity to review this the way I really would like to, but I'm just concerned that especially in a long-term marriage with multiple children, because you're already, let's say you have 3 children, you're already looking at 32% of the pair's net income paying support.
Plus a statutory percentage for maintenance.
Right.
Which today, how does that work today in our courts?
It depends on your judge.
I hear you.
And that's, and I know that that's a really hard thing for people to hear, but it really does depend on your judge. I mean, you have to you take your maintenance off your gross income, and then you also have your child support calculation in there, and it's you have to look at what happens.
Are judges generally, and obviously I know you're saying things depend on the judge, but are judges generally sensitive to how much someone is paying in child support to their determination of how much maintenance they should get?
I think so. I think judges definitely look at that because you have to be realistic. I mean, everybody has a right to eat. And sure. One of the key issues for maintenance, and this is a little off the topic, but it's not about who did what. Okay? Maintenance is going to be determined irrespective of marital misconduct. And so you're not going to get maintenance based on what he or she did to you. You're not going to get maintenance because he cheated. You're not going to get maintenance because she was whatever she was. There's lots of words we use badly about women sometimes. That's not what maintenance is about. It's strictly about the dollars and cents of this situation. The other piece that the court needs to really look at are the tax consequences. For example, if a person is receiving child support and they also are receiving maintenance, the child support is not taxable to that person, but the maintenance is. If you ask for, let's say you're making $25,000 a year, and then you also are asking for an additional $2,000 in maintenance each month, are you then basically asking for so much maintenance that it gets you out of the earned income tax credit? That it gets you out of a position where you can get where now you are paying so much taxes that basically you're taking your maintenance that you're getting and giving it to the IRS. Well, what's the point of that? So we should be considering the tax consequences of the maintenance award, because otherwise you're just getting maintenance to give it away. You're not actually benefiting from the money that's being received.
How are some of the ways that that a party can get around some of those tax consequences?
Well, I don't know that you can as it relates to maintenance, but one of the things that a party can do is do an unequal property allocation instead of maintenance. One of the examples that I use a lot, just what little bit I know about it, is Hulk Hogan's divorce. Okay. I believe she received 80% of his property at the time of the divorce. It was an 80-20 split, but he's not paying maintenance.
Well, isn't that unfair?
It is unfair, but everything that he makes after the date of the judgment is his. He doesn't have to pay maintenance, and with the property settlement, it's not considered income. You're not paying taxes on it.
So Hulk Hogan knew, or was pretty sure, that he would continue to make a lot of money.
I would imagine so.
He wouldn't owe her anything. He could keep that money. She got 80% of the property.
Correct.
And didn't have to pay taxes.
Correct. Because,
smart.
For example, let's say you have a house that's worth $100,000. And let's say you have been married 40 years and your house is paid for. Well, one thing the husband may do is say, okay, I'll give her the house. So he's given up $50,000 in equity, but I don't want to pay maintenance.
Sure.
Well, she's received a $50,000 asset with no tax consequences. She can sell this house tomorrow. Now, I'm not sure how that's going to work, but at least for today's purposes, there's no tax consequence to that.
And receiving a $50,000 asset with no tax consequences might be more like a $70,000 asset.
Exactly.
Like you spoke briefly about maintenance is ordered regardless of marital misconduct.
Correct.
Can you go into detail about that a little bit?
What that means is, regardless of who did what to whom, you're not going to make money because he or she did something you didn't like. The purpose of divorce court is not about who did what to whom. Quite frankly, getting in divorce court, the grounds for divorce are your admission ticket to get into court. After that, the judge doesn't really care, except if you are spending money on things outside of the marriage. So, for example, if you were taking marital money and spending it on your new significant other, that is going to be an issue because you are essentially doing what's called dissipation. You are taking marital assets and spending them for non-marital purposes. Now, is the judge going to say, well, you did a horribly bad thing, I'm now going to punish you, you must pay $20,000 for the $150 dinner you took your new significant other on? No. Well, you may have to pay the marital estate back its portion of that money. So if you spend $150, $75 you may have to pay back to the marriage because it was not a proper way to spend marital funds.
So the judge isn't so much concerned about whether or not you did something moral or immoral.
No.
What he's saying is you took some of your wife's or husband's money that would have gone to her or him in the property settlement.
Correct.
And gave it to another person.
Correct.
And that's not fair in terms of using their property for something like this.
Absolutely.
Okay. But that does not, testimony cannot be brought in a maintenance case about whether or not you're having an affair or something like that.
I'm not saying it can't be brought in, but what I'm saying is the judge should not be awarding maintenance based on the party's bad conduct.
So we talked about the 4 different kinds of maintenance. Any other types of maintenance?
Don't believe so.
And then we talked about the new legislation. Are there the new proposed legislation that might be forthcoming? And then you listed the factors. Are there any of those factors that you think are most significant?
I think the income of the parties is most significant.
That makes sense.
I also think the party's age and physical and emotional condition.
In terms of age and physical and emotional condition, why is that so significant?
Well, significant because, if you are in your 50s and your spouse is chronically depressed, has been so for a long time, has been unable to work, can't work, that may be a maintenance case. If they can't find any other source of income or assistance, you married that person, good, bad, or indifferent, and now we have to figure out how to separate things, and that person may be entitled to maintenance.
Anything that we have missed in regards to a discussion about maintenance that you think is important?
I think it's important just to realize that every case is different. Every case is unique. The factors of every case are different. And even with this new proposed statute, every case is fact specific. No case is just like the next one. There are no standards in divorce court, a standard answer, a standard amount, because every situation is different and every judge is different. And judges on different days are different. It's very unpredictable. But I think as practitioners, we do our best to try to explain that and then work through that knowing that that's the situation.
Well, Tamika, I appreciate your time today.
Absolutely.
And, this kind of information, I'm sure, will be very valuable for people who realize they're going to be paying maintenance or they're going to need to receive maintenance.
Yes.
You are an attorney at Serena & Kane, correct?
I am.
And where is Serena & Kane located?
We are here in Rockford. We're at 321 West State Street on the 7th floor. And I handle all of our incoming family law cases.
And if someone needs to contact your office, what's the phone number here?
815-962-5490.
Great. Well, thanks again, Tamika. I appreciated talking to you.
Thank you. Have a good day.
You too.
You just heard a phenomenal episode of Divorce Talk Radio. Listen to Divorce Talk Radio live on RockfordCollegeRadio.com Tuesday evenings at 8 p.m. To hear more of Divorce Talk Radio shows, please visit RockfordCollegeRadio.com. To learn more information about attorney Brad Tangler, please visit TanglerLaw.com.